Welcome to Radio Entrepreneurs. I'm Jonathan Friedman in the studio, joined today by our good friend Mark Furman. Mark from Tarlow, Breed, Hart & Rogers. Mark, how are you today?
Great, Jonathan. Great to be with you.
Always great to be with you, Mark. And I hear you've got an exciting case to discuss today. You're a happy man.
Well, a case that we prevailed in the appeals court on behalf of our client, but has some, I think, important messages for business owners and entrepreneurs.
Great. First off, congratulations. Always nice to win a case.
Yes.
And I know that's not a rare occasion for you. I know it's a common occurrence. So just wanted to congratulate you on that. And I'd love to hear about the case and about the implications for business owners.
Okay. So my client was a non-bank lender, and in the business of making high risk and high interest loans on a short-term basis to business sophisticated borrowers. These are people who were not bankable, not able to get financing from banks. In this case,
so traditional, not able to get traditional access to capital based
correct.
On whether credit or past history or various issues.
Correct. In this particular case, the borrower had a felony conviction, which would make him not an attractive borrower for a lender. So there was a short-term loan made, somewhat over $1 million, and it had to be repaid in 90 days. And it provided for interest at the rate, I think it was 18%, but default interest of 21%. Under Massachusetts law, if you're going to charge more than 20%, you have to register with the Attorney General's office to make sure, so that they can make sure you're not involved in loan sharking or that kind of conduct. Liquidated damage clause, you see them in real estate contracts all the time. If you ever purchase and sale agreements, you put down a deposit if you're buying, and the agreement usually reads that if the buyer defaults, the seller keeps the deposit. That's a liquidated damage clause. And they come up in all sorts of contexts, real estate leases, business deals, purchases and sales of businesses, purchase and sales of real estate, supply contracts, requirements contracts, all sorts of contracts for all sorts of things. Patriot season tickets, seat licenses. They sell 10-year seat licenses at Gillette Stadium, and what happens if you don't pay? What are you liable for? So liquidated damages clauses are a source of constant litigation. Lessons for business owners and entrepreneurs. One, please read or make sure you have someone read the fine print in every contract. We always have these terms and conditions in small print when you enter into agreements, and sometimes the seller's fine print is totally inconsistent with the buyer's fine print. And do you know what the deal is, and do you know what the repercussions are if there's a problem? My experience is people usually don't read them, and they're getting read for the first time after there's a dispute.
I think what people do is they tend to look at these things and say, okay, what are the terms? The terms look good based on whatever negotiation. And then the rest is quote unquote boilerplate. So everybody must be subject to the same thing. So it must be fine.
Yeah. And there is no such thing as boilerplate, but that attitude that it's just boilerplate pervades the business community. And the result is that it's not uncommon for folks not to know what they've agreed to. My main point is, know what you're contracting with. Don't make assumptions, and please don't use the term verbally or mentally just boilerplate.